Week number 2 of jury selection continues this morning in the trial of 3 white men charged with murdering Ahmaud Arbery. It's proven to be a slow process. Right now, court is in session, so we're going to take you inside the courtroom to listen in. The judge presiding over this case right now as he listens to some of the motions from the defense and the prosecution as they continue this process, which has been a very slow process. Let's listen in Glenn County, Georgia right now.
But I point out, I mean, and there's case law all over the courts. I'm just going to put it on the record at this point. Questions seeking to test prospective jurors' willingness to accept defenses or to identify jurors who are amenable to a particular defense are properly disallowed. That's Meeks v. State, 216 Georgia App, 630. It's a 1995 case, most recently cited, at least that I could find, in. Yeah, I'll just tell you where it's most recently cited that I could find. It may have been cited again since this. Recently cited in Stewart v. State. 262 Georgia App 426. Let's see. Stewart, it goes on to explain there's often a fine line between asking potential jurors how they would decide the case and questions that merely seek to expose bias or prejudice. The scope of voir dire, of necessity, must be left to the sound discretion of the court. Then goes on to explain the Court of Appeals is not going to interfere with the discretion, absent manifest abuse. Goes on to talk about questions of technical and legal nature and questions that call for prejudgment are improper in voir dire. So as to these additional questions on defenses, the court's permitting the parties to get into consideration of the defenses, fair consideration of the defenses. The court's comfortable with where we are with that, so that will be the court's ruling on those questions.
All right, my apologies. Let me make sure I'm understanding what the court is saying. This is the ruling on the questions that we've included in the email.
This is the ruling generally. The court has already permitted the parties to ask about defenses and fair consideration of the defenses,
right.
Naming the defenses. Those have been asked. What I'm saying is there are limits, and so I'm not going to rule on additional questions. What I'm going to do is if we go beyond where we've been with these jurors, if that's the intent, then no, if there's an objection, it's going to be sustained because I believe the court has permitted, in fact, maybe even permitted more than would otherwise be permitted given the nature of this case, because the court has been flexible given the amount of information that has pushed out there or been pushed out there. In this particular case, I've gone farther than I normally would anyway. So what I'm telling you is the line is, you can ask them those questions about whether they'd give fair consideration to defenses, but we're not going to get any further into it, and there's support here for that.
And Your Honor, we do appreciate your latitude to us because of the nature of this case, and I want to concede on behalf of the defense that the line, and I'm quoting now from Ellington, the line between permissible inquiry into prejudice, which is then defined by the Supreme Court of Georgia as follows: a juror's fixed opinion that a certain result should automatically follow from some fact, regardless of other facts or legal instructions. Okay, the line between that, which is prejudice, and impermissible questions of prejudgment, and we have gotten many objections that we're calling for prejudgment, which is defined as speculation about or commitment to the appropriate result based on hypothesized facts. And then Ellington ends that sentence by saying that that line can be hazy, and it is. It's tough, and I want to assure the court that we on the defense side are trying to stay on the prejudice side of the line and not on the prejudgment side of the line. We're honestly not interested in laying out some facts in our case and asking jurors essentially, now how would you vote on that? What we're really doing is what Ellington itself says we're allowed to do when there are critical facts in a case that a juror might say when hearing them, that's it for me, that's all I need to hear. I don't need to hear any more evidence and any more law. And some of those facts in our case are ones that we've asked about. And the one I just indicated we'd like to add is, and again, this comes up in the course of conducting these examinations, and you begin to hear how these people are actually thinking and responding. And so it requires the adroit criminal defense lawyer to shift and change.
You already know.
Yeah. Well, here's the thing, and I don't know if we still have that lower third, as we call it in the industry, that talks about addressing an unfair system. The defense wants to, and it's very
Accompanied
distracting
by
to hear him.
movements. That's what it
Yeah.
said.
Accompanied by movements. It's actually crazy. At one point in America, are we going to continue to hear just the talking? Because we can listen in if you like. We'll listen in.
Of what we're allowed to ask, and I think I'm hearing the court say, and again, forgive me if I misheard, that if we go beyond that or ask a new question and it draws an objection, it will be sustained. I think I heard the court say. So if I was to ask this question today, which,
How could I, that doesn't make any sense to me.
well, again, I might have misheard.
Let me talk. If you ask a question and there's an objection made, I'll rule on the objection at the time. What I've said is that it's pretty clear what the parameters are here. I'm permitting questions about whether or not that the potential juror would consider defenses. Now, that's even a little bit further than some courts have said is okay. What you're suggesting is that additional inquiry needs to then occur. And what I'm telling you is that is potentially objectionable. Under the circumstances with that juror, if an objection is made, I will rule upon it, but I'm giving you what the court's position is right now. So, I mean, if you want to go ahead and debate it with any potential juror, make your record, but I'm telling you right now that the question that you proposed as additional questioning, for additional questioning, may be objectionable, and the court's told you where I'm getting that authority from, because I think it may go a little bit too far in this particular case.
And you're referring to the questions that we've included in this email, plus the one I just added?
No, I simply said you brought one more, one that's not even put in the email that you wanted to add in today. That's what I'm talking about. You started talking about the defenses and consideration of defenses and how you wanted to get into additional questioning on defenses. And what I did is I stopped you right there and said, okay, on that particular issue, let me just tell you where I am with the law, and we can just move on. And we can get back to
All right, so that's
Judge
Judge
Murray.
Timothy Walmsley. Yep, he's admonishing in defense. You mentioned the lower third, the motion unfair system accompanied
this is what I
by
wanna address.
movements. There you go.
Yeah, this
So
is what
have at
this
that,
is
Sharon.
America. You better sit your down and shut up. Okay? Let me tell you about addressing an unfair system. Ahmaud Arbery was recorded in his final moments and called an N, gunned down while out for a jog in broad daylight. I didn't even see people run out of their houses and say, oh my God, let's render aid. Matter of fact, nobody did render aid. Remember that part? And then the good old boys at the local newspaper said they had a trespasser, burglar, and he was shot dead, nothing to see here. That's your unfair system, okay? And then it took 600 days, his grieving mother said, to even get to a courtroom. So you want to unpack an unfair system? Black Lives Matter is not a movement. It's breath. It's our very breath, okay? This is the height of white privilege, and I'm well aware that we're inside a courtroom. White people don't get it. The ones who wrote me and said, Sharon, how dare you in this moment? It's not the time to bring up the Gabby Petito and missing white woman syndrome. That's precisely the time, and you don't understand that there are black mothers who love their children just like you love yours, who are grieving in that very moment. Unfair system is being a black boy gunned down in broad daylight in the middle of the street. So with all due respect to his honor, we done seen enough, okay? They better get it right.
Right.
They better get it right in Brunswick, Georgia.
Well, you know, once again, coming off of what happened to George Floyd, we once again take one step forward, and then sometimes we take 2 steps back. So we got to keep that progress going. So yeah, get it right. We want justice when it comes to that. You talk about the unfair system, the fact that he was gunned down while jogging through a neighborhood because he had a couple of vigilantes who thought they were doing the right thing and filmed it, feeling like that was the right thing to do at that particular time, and then using the N-word, unfair system. The newspaper, unfair system. Oh, let's go a step further. The fact that it took so long for this to even come to our attention, unfair system. The fact that it almost didn't even go to trial because you had a prosecutor who did not want to do her job because of a personal relationship she had with some people or the defendant in that community. That is part of the unfair system. So miss me with the unfair system talk, because we've been dealing with an unfair system since the beginning of time, and we continue to deal with an unfair system, and that's what we fight for. Until the system is fair for every one of us, that is our push. So forget that. But anyway, the defense guys trying to do their job. I understand that, but hopefully Walmsley is doing his job and shooting it down like he is. All right. Remember, of course, we are your go-to for extensive trial coverage. BNC committed to following the latest in the journey for justice for Ahmaud Arbery. Keep it here and on our sister streaming network, BNC Go, for the respective you will not see anywhere else.